Thank you for joining me for another episode of Boom and Bust. I'm your host, Tony Clement, here at the News Forum where all voices matter. A more competitive economy needs more than new companies willing to take on incumbent giants. It also needs a legal framework that values competition. Our two guests have written about the way our country's competition laws need to change to better balance out efficiency and competition. Vas Bednar is the executive director of McMaster University's Master of Public Policy in Digital Society program, and Robin Shaban is principal at Vivek Research, an economic consulting firm. Thank you both for joining me today.
Thanks for having us.
Thank you.
Vas, maybe you can start us off, and Robin, please feel free to chime in, but what spurred you to write about this issue in the first place?
There's this environment right now where there are these historic antitrust suits taking place in other jurisdictions, the EU in particular, but the US as well. And I think because we're a country that often copies and pastes when it comes to public policy, there was an expectation that we might follow suit and mimic these suits, actually, not to use the word suit too many times. But that got us curious, is that viable for Canada? Is that something we will do? Can we do it? How does our legislation kind of stand out in that regard? And then Robin and I had recently met and just had this great opportunity to start becoming thought partners and examining the relevance of the Act for this digital day and age.
Robin, what's your perspective on this?
Yeah, I agree with Vas that I find Canadians, they often look to the States. And when I talk to people, they actually believe that our antitrust or competition law system in Canada is similar to the US. They read American news as if that's what's happening in Canada, but that's not true. And Tony, I really liked how you started off the segment by saying that it's not enough for Canada to have new firms that are willing to take on incumbent giants, but we need a legal framework to support that. And Canada has historically taken this really laissez-faire approach, which actually doesn't provide the legal framework we need for robust competition. And I'm a bit of a nerd with this stuff, so I find it always fascinating to see how Canadians believe the system is in Canada versus how it really is. So for me, the several op-eds that Vas and I have done, as well as a report that we've recently released in collaboration with McGill University, really, I hope, highlights the deficiencies we have in our system and how that undermines competition in Canada.
Yeah, I'd like to get to your report because that is very interesting for me as well. Robin, before we get to the break, though, maybe you can answer this first. How historically have competition laws had that balance between efficiency and competition? Has it been a good balance, a bad balance? You go first, and then we'll give Vas the opportunity as well.
Sure. I think that we're still working to find that right balance. The idea that competition law, or antitrust law, as they call it in the US, is supposed to promote efficiency came out of thinking from the 1960s that actually came to revolutionize the way that thinkers in America and Canada understand the role and purpose of competition policy. And I think it's fair to expect our competition laws to promote and protect efficiency, because efficiency is important for a healthy economy and a healthy society. I think that there's a pendulum swing happening within the area of competition policy, where we've taken this, I call efficiency's obsessive approach. And I'd like to see competition policy come to a more centered and grounded approach, where we're understanding the role of efficiency as well as other important outcomes of competition, like fair consumer prices and product variety, as well as other outcomes.
And they're not being valued right now?
I would say that's accurate. I'd say there's a real difference between the rhetoric of competition policy and the actual nature of it and how it actually plays out in the Competition Act, which is our legislation, our competition legislation in Canada.
There's kind of two.
Sorry, Vas, we are going to get to you, but we've got this thing called the commercial break. You'll be first up after that. Please stay with us. And welcome back to Boom and Bust. I'm your host, Tony Clement, talking about competition laws and how this helps or hurts competition and companies in Canada. Vas, I cut you off there before the break, but certainly give me your perspective on how historically competition laws have tried to play off efficiency versus competition.
Sure, I'll offer a couple of things. I mean, one, I think philosophically, we in Canada have privileged growth in order to achieve international competitiveness, right? This is a spirit that might have motivated some of the attitudes that are reflected and now enshrined in our existing legislation. But there's kind of two opportunities. Robin's been pointing to the fact that as it stands, Canada's competition policy really stands out in an international context, right? And we take fundamentally different approaches. We have a much higher threshold or burden of proof before we can even investigate firms. And when we do look into merger reviews, we don't have comparable powers in order to do market studies, to compel particular information. We're under resourced, et cetera, et cetera. So there's that factor. And then there's the other factor, which is just that from a digital age, from a digital context, our competition policy is just silent and needs to be refreshed just because it's fallen a little bit out of date, but that's not necessarily intentional. That just happens.
Right.
And as it stands, our legislation hasn't been updated in about 20 years. So you think about how our lives have been revolutionized by large digital firms and small digital firms. And you realize, we're not just competing on price anymore. In a lot of ways, companies are competing on data or privacy. And there's a digital dominance element that if Canadians don't update, if we don't update our own legislation, other competition authorities, no matter how powerful they are, they're not going to come and investigate issues happening in our own backyard. That's going to be up to us. And if we don't update the legislation, then we're just ignoring a growing part of our economy. And I think hurting competition without even knowing it.
Indeed. Now, Vas, you and Robin just penned a new report on this very matter. Can you explain that to our audience, please?
Sure. So it's a report on the state of competition policy in Canada. Robin, I'll turn it to you, but really it's, if anything, it's a kind of primer, a backgrounder. Let's get a common ground. Where did we start from? What are the philosophies that underpinned Canada's competition policy? How does competition policy even work? And then placing that in an international context to kind of look ahead and identify some opportunities. Where can we be learning from other jurisdictions? And earlier we mentioned copy and pasting. And it's good to learn from other jurisdictions, but we don't just have to import existing frameworks. Like Canada can still maintain its unique approach to competition policy and actually has some opportunities to lead. Mm-hmm. But I'll turn it to Robin. She's really pro on all of these things.
For sure. Robin?
Sure. Well, what I really enjoyed the most in this report was really thinking through what makes digital firms different than the typical businesses that we see in Canada historically. Because when our Competition Act was enacted in 1986, we were living in a whole other reality. But it's only been in the last few decades that we're seeing a revolutionization of commerce with the rise of digitization. And so we've spent a lot of time thinking about what makes digital firms different and what does that mean for competition? Something that I find astounding, it was a fact that came up in our research 20 years ago. It would have taken decades for the typical Fortune 500 company to receive a $1 billion valuation. Now, digital firms can do that in as little as 4 years. And it's because we're talking about digital platforms that transcend borders. They're not physical businesses in the way that we understood business when we created the Act. And so we're in this whole other reality. And I think it requires a whole other approach to understanding competition. Like Vas was saying, what is the role of data in creating dominance in our businesses? which then can lead to potential competition issues.
Well, I think you're onto something there. And I guess we've got about 30 seconds before the break, Robin, but I'll give you the first crack at this. What are the impacts on the economy to having an out-of-date competition legal structure?
Well, I think for me, what is really important is not only having an efficient, productive economy, but also one that's equitable. An economy where everyone can participate, they all have an opportunity to engage. And when we don't have rigorous competition, it's harder for businesses to start up and to have innovative products enter the market that benefit everyone.
We're going to take another short break, but we'll be right back with Vas Bednar and Robin Shaban. And we're back here at Boom and Bust. I'm your host, Tony Clement, here with Vas Bednar and with Robin Shaban. They are both experts in competition policy. Vas, I wanted to give you a chance, first of all, just to talk about the economy and how this fits into that. And then I've got another question for you.
Sure. I mean, one way that the economy fits in is, don't forget, competition policy is offers a broad framework, some guidance for firms, what's permissible, what's not. And if we're not defining digital dominance and not considering what the role of data is and how companies can use massive amounts of data that they might be able to acquire, then I think we risk being, disingenuous if we are trying to retroactively apply new interpretations of that law. I mean, look, you're the one trained as a lawyer, so you can jump in with us. But I think that is a risk, and it's difficult to quantify, but it's not hard to see. For instance, there are certain antitrust suits looking at how Amazon uses information in a range of ways. One is, just by virtue of owning a platform and advertising on it, they're collecting a lot of information in terms of what people want, what they're willing to pay, what's in demand. There's one claim that they might be leveraging that information to inform their own products. But if that's something that we're going to say is not permissible or is anti-competitive, we need to, I think, be a bit more clear about that instead of looking for new behaviors and then, I don't want to say flipping a coin, but struggling to interpret them. That said, there are firms that have the power, the ability to mimic some of what Amazon does, or even just privilege their own products in search. Is that necessarily an abuse of their dominance? That's for Robin to tell us and others. But I think there's a pattern recognition that we need to either have reflected in our legislation or accept that our silence has made us sort of signal that these behaviors are okay, but they're not in consumers' best interest necessarily. And that's another major difference with Canada's competition policy. It is so fundamentally decoupled from consumer protection that it kind of forgets about people. And it's sort of intriguing. Robin, you're nodding.
Yeah, you're nodding, Robin. So if you want to add something, please do so.
Yeah, well, just to add that Canada is unique in that we have a distinct chasm between consumer protection and competition law, whereas in many other countries, these two functions are together. They're often in the same agency. And this comes back to what I was talking about before, about this obsession that we have in Canada about efficiency. And our system is built on this assumption that free markets can take care of themselves, which I think we can expect businesses to take initiative and be competitive and want to compete, but we also need clear rules of the game. And like Vas was saying before, if we from a regulatory standpoint, are wishy-washy, we lack confidence, we're not clear on what's anti-competitive, what's not. This isn't good for businesses. I think businesses, this is my view, I'd be interested to hear what other people think, but I think that businesses would be okay with tougher competition laws if the expectations and rules were clear and everyone knew the rules of the game.
Right.
There may be big incumbent firms that have a problem with tougher laws, but I think for most Canadian firms, especially small and medium-sized ones, they'd welcome change, especially if those changes were clear and confident.
Vas, we've got about a minute and a half before the break. any thoughts on comparing, contrasting Canadian competition laws with U.S.? I mean, that's the big elephant in the room, I guess. So, any thoughts on that?
Sure. I mean, one thing that's really unique about Canada, don't forget, we've nested the Bureau in the Ministry of Innovation. So many are of the mind that the Bureau needs more independence, intellectual and otherwise, to be informing policy that it then also enforces. The policy capacity of our Bureau has been diminished. We are comparably under resourced, but don't forget, in the US, there are also state led authorities that look at competition, so they can run much more of a full court press. I'd also mentioned the ability to conduct a market study. I mean, that's straight inspiration from the US right there, because
Right.
we can't do that. And that said, we can benefit from their investigations because that information can become accessible to us. We can also benefit, and we will benefit, if there are meaningful business changes from a large technology company perspective from these suits in the US and the EU because of those spillover effects. But again, when it comes to our own backyard, that's our job to make sure that our legislation is clearly governing our firms in a way and providing those guideposts in a way that's responsible, clear, and modern.
We're going to continue our discussion after this break. Please stay with us. And welcome back to Boom and Bust. I'm your host, Tony Clement, discussing competition policy with our two guests here. Robin Shabin, I'll throw this one to you because you kind of alluded to this earlier. All right, the big elephants in the room: Google, Amazon, Facebook, Twitter. What do we do about that?
Well, in an article that Vass and I recently did, we make the argument that the U.S. and EU authorities have already started to take action against these large digital giants, and in fact, their action may be beneficial to us, both because of the international scope of these businesses, but also Canada can act as a second mover in these enforcement actions. So they can look at what's been successful legally in the United States and mirror that. So I'm not super concerned about the digital giants and how they are operating in Canada, because I think we can benefit from a lot of action that's happening elsewhere. But back to Vass's point, we really need to be taking initiative about digital firms in our own backyard. One company that we talk about a lot is Loblaw. Loblaw has taken a lot of initiative to collect and leverage data on Canadians, and this can have far-reaching impacts on our lives. The grocery sector in Canada overall, it's very highly concentrated, and we've seen evidence of some very troubling competition issues, especially as it relates to workers throughout this pandemic and the freezing of hero pay. So again, there's very serious issues that could be happening in Canada that we don't have the tools to address, and that are increasingly becoming digital problems, which are moving them even further out of our legislative reach.
Vass Bednar, you mentioned at the top that this law, the competition law, is set for review. What do you expect to happen or hope to happen?
Well, I hope that we're able to engage a range of voices in a really meaningful and interesting way when it comes to reviewing that act. I think this moment with the proposed Rogers-Shaw merger, I think with some big tech cases that are making headlines, I don't want to say competition policy is necessarily cool, but it is capturing public imagination a little bit more. There are more tangible examples for people to grab onto. And I'd like to see us really thinking critically about more than just enforcement capacity, and stepping back and being like, well, what are we enforcing on? And what does that mean? And kind of maybe also getting on a schedule so that we just refresh our legislation, maybe in the same pace. I think if we look at the Banking Act every 5 years, like we should do that for competition policy too, because what we're seeing is the landscape and the economy changes quickly.
Robin, you've got the last word. What do you hope to see out of reviewing the legislation?
To build on what Vass was saying, I'd like to see a broader conversation that includes a lot of diverse perspectives. Because the funny thing about competition policy and competition law is that there are competing interests. like what we talked about before, big businesses may not be super keen on revising our Competition Act, yet consumers, I think, would be very interested to see some positive progressive change. Workers also have a role to play in the conversation. And right now, in my view, the conversation is dominated by corporate lawyers that represent the businesses that are engaging with the Competition Bureau. And these people have a lot of brilliant expertise to provide, but we need other perspectives there too that are as equally as informed and can help to balance these different interests so that we can create a legislation that serves everyone to the best of our ability.
Well, I guess we'll all see together. I want to thank our guests today, Vas Bednar and Robin Shabin, for their incisive commentary on Canada's competition policies. Thank you, both of you.
Thanks so much.
I'd like to thank both Vas and Robin for their attendance. A very interesting area. You may not think of competition law as a top of mind thing, but it does control, the vastness of some of these companies and their control over aspects of our lives, digitally or otherwise. And of course, having 20-year-old laws when things have been changing so quickly probably is not to Canada's advantage. So I certainly wish Vas and Robin well for pushing the point that we need to have change. Thanks for watching.